Hello everyone, good afternoon to all of you. Welcome to UN Digital Class. Today I am going to deliver a new chapter that is relating to Indian Partnership Act. So one by one we will discuss everything. What is a partnership, who are the partners, who are eligible to partners, what are the different types of partners or different types of a partnership, what is the registration of partnership and what is partnership deed. Introduction. The law of partnership is contained in Indian Partnership Act 1932, which came into force on 1st October 1932. A contract of partnership is a special contract where the Partnership Act is silent on any point the general principle of the law of contract apply. The Act extends to whole of India except the state of Jammu and Kashmir. So Indian Partnership Act or the law relating to partnership that is contained under Indian Partnership Act, that act was established on 1st July 1932 and this act is extends to apply whole of India except the state of Jammu and Kashmir. So what is the meaning and definition of partnership? Section 4 para 1 of the Indian Partnership Act 1932 that defines partnership. Partnership is the relation between persons who have agreed to share the profits of the business carried on by all or any of them acting for all. Hence, partnership is the name of legal relationship between or among persons who have entered into a contract. So, the definition of Partnership Act, if we focus, that is contained under section 4 of the Indian Partnership Act 1932. That definition signifies that partnership is the relation between persons. That means when persons, two or more than any members, they enter into a legal relationship to start on the business or carry on the business with some objectives, then the relationship between the persons is known as partnership. So simply we can say that partnership is the relation between persons who have agreed to carry on the business acting by one or any of them all. And the relation between partners, that is the legal relationship and that arises out of the contract or the terms and conditions mentioned between the partners. Now we will focus who is a partner, what is firm and what is firm name. So that is mentioned under section 4 of Indian Partnership Act 1932. Persons who have agreed into partnership with one another are called as individually partners. So partners means the persons enter into the partnership firm or those enters into create a legal relationship with each other. So all are called as the partners to the firm. The second one is firm. Generally the partnership business is collectively known as firm and the name under which the business is carried on is called as firm name. So firm name signifies that when a partnership business is carried on by some persons or more than two persons, so what the name they enter into or what the name they constitute as partnership business, that name is called as their firm's name or partnership business name. So partnership, hence the invisibility which binds the partners together and the firm is visible form of those partners who are thus bound together. So generally partnership is invisible, that means we cannot see that, but the persons or the partners, those enter into the partnership firm, so that is collectively known as firm and that firm is the visible form of the partners who thus combines together to carry on the business acting for all or any of them. So next is what is the maximum limit of numbers in a partnership business. That is mentioned under section 11 of the Company Act that provides that the maximum number of persons a firm can have. In case partnership business carry on a banking business, the number is maximum 10. So when a banking business is carried on and that is a partnership firm, so the maximum number of persons or the partners in banking business is known as 10 and in case of a partnership firm carrying on any other business, that is 20. So for banking business the maximum number is limited to 10 and in case of other business, that means other than banking firm, the maximum number that is limited to 20. If the number of partners exceed the aforesaid limit, the partnership firm becomes illegal association. So the number is mentioned, the maximum number of persons or partners, that is mentioned as per the Partnership Act. If the partnership firm or any of the firm exceeds that number, then in that case that firm is illegal business, or that is called as illegal partnership firm. So there are certain essentials of a partnership business. The first one is at least 2 or more persons, second one agreement, the third one is business, fourth one is sharing of profit, and the fifth one is mutual agency. So we will discuss these 5 points one by one. The first one is association of 2 or more persons. A partnership is an association between 2 or more persons, and persons by law only includes individual, not other firms. The law also prohibits minors from being a partner, but minor can be admitted to the benefits of a partnership business. The act is actually silent on the maximum number of partners, but this has been covered under Company Act 2013. So a partnership can only have a maximum 10 partners in a banking firm and 20 partners in all other kinds of a firm. So association of 2 or more persons, that means simply we can say that as per the definition under Partnership Act, generally partnership business is an association of more than 2 persons. So when 2 or more than 2 persons, they have associated, they have combined, they enters into a relationship or forms an agreement to carry on the business, that business is known as partnership business. So this is known as association of 2 or more than 2 persons. So the maximum number, that is not mentioned as per the Partnership Act, but as per the Indian Companies Act, that is on 2013, or when the Company Act was established, it was mentioned that the maximum number of persons in case of a banking business, that is limited to 10, and in case of other than banking business, the maximum number is limited to 20. So this is relating to your association of persons in case of a partnership business. The second one is agreement. The second essential element to constitute a partnership is that there must be an agreement entered into by all the persons concerned. So partnership results from a contract or an agreement between 2 or more persons. A partnership does not arise from the operation of law. It has to be a voluntary agreement between partners. A partnership agreement can be written or oral. Sometimes such an agreement is even implied by the continued action and a mutual understanding of the parties. So the second point, that is relating to agreement. When 2 or more than 2 persons are associated with each other, or they enters into form a partnership business, they must continue or to form an agreement, or they must enter into an agreement with each other, and that agreement mentions the terms and the condition to carry on the business. As per the agreement, they must have to carry on the business, and that agreement may be written or in oral. When partnership business is formed by a written agreement, so that must have been written in a form of a paper, and every partners, those enters into the partnership business, they must follow or apply that rules or code of conduct at the time of conducting the business. In certain cases, the partnership business is also arises out of a implied condition or implied words through them to carry on the business, and in that case they must have to be follow that what they have implied made at the time of enters into the partnership business. The third one is business. There are 2 aspects of this element. Firstly, the firm must carry on some business. Here the business will include any trade, profession or occupation. Only that some business must exist, and the partners must participate in the running of such business. So when partners enters into or they forms an agreement with each other, that means the partnership firm is related to business. So here business means any type of a trade or commerce or industry they have to form, and they have to be contribute their activities or their role or their money to carry on that type of a trade or industry or commerce, whatever may be, but that relating to certain kind of a legal or lawful business. And only some business are exist, partners must participate in the running of such business. So who are the members in the partnership business who carry on that business, they must have to be participate or they must have to be contribute their role relating to running of that business, and the business must be run with a profit motive. That is very important. The ultimate aim of the business should be make gains which are then distributed among the partners. So firm carry on charitable work will not be a partnership business. If there is no intention to earn profit, there is no partnership. So business is relating to with a profit motive. Partners, those are starting their business, their main objectives to earn profit, as every business main motive is profit earning, and that profit is utilized for expansion and diversification of their business, and what the profit they derived from the business, they have to be shared among them as per the profit sharing ratio. Any business without any profit motive is not called as a partnership business, as any charitable institution which are conducted without any profit motive, that business or charitable institution is not as a partnership business. Then the fourth one is profit sharing. The sharing of profit is one of the essential element of a partnership business. The profit sharing ratio or the manner of sharing profit is not important, but one partner cannot be entitled to the entire profits of the firm. So this is very important. Whatever profit they derived from their business or partnership business, those are the members relating to the partnership business. They must have to be contribute, or they must have to be divide their profits as per the profit sharing ratio, and that ratio is mentioned in the partnership deed. So the partners, those are involved, they have the rights to take their profit portion. Any one partner, if that is taking over all the profits, that is not legal. So that must have been distributed or that must have been shared, and that is as per the profit sharing ratio mentioned in the partnership deed. However, the sharing of losses is not any essence. It is up to the partners whether the loss will be shared by all the partners. If nothing is shared, then losses are also split in the profit sharing ratio. So we have discussed relating to profit, and profit is distributed as per the profit sharing ratio. In case business in any year suffered any amount of losses, so the sharing of losses is not essential. But if nothing is mentioned sharing of losses, in that case that is spilled over profit what they have earned before. The fifth one is mutual agency. This definition states that business must be carried on by the partners or any partner acting for all of them. This is a contract of a mutual agency, another one of the 5 essential elements of a partnership business. So mutual agency signifies that those are the partners relating to the partnership business. Business is carried on by all the partners, or any of them is acting for all other partners. If there are 5 partners in a partnership business, one partner is active, so that business is carried on by that one active partner, and what the decisions or the roles that is performed by that active partner, that must have been followed by other 4 partners. If the 5 partners are active, then they have to be conduct their activities, or they have to be distribute their activities as per the performance of the business. So this is known as mutual agency. The mutual consideration has been made between all of them. Either all are active or any of them is called as active, and a other must have to follow the rules and regulation implemented by the active partner. Then this means that every partner is both a principal as well as an agent for all other partners of the firm. An act done by any of the partner is binding on all the other partners and the firm as well. So every partner is bound by the acts of all other partners. This is one of the most essential aspect of partnership business, and this is known as true test of partnership business. So we discussed in detail relating to that mutual agency. Mutual agency that refers to the relationship of a principal and agent among the partners. So when one partner is called as active partner, that active partner is treated as principal and others are his agent. So relationship between principal and agent is one type of a mutual agency. So there is one example. In a partnership firm, A, B, C are 3 partners. So when A is acting as an agent, then B and C are the principal. So the B, C is principal, and out of the 3 only one A who is as agent. Then in other cases, if B is an agent, then A and C is called as the principal, and if C acts as an agent, then in that case A and B is principal. So in each cases, these 3, One is acting as agent and other two is acting as principal. So this is called as the mutual agency or the true test of partnership business. Then we are going to discuss different types of partners. There is one that is actual partner, second one is sleeping partner, the third one is nominal partner, that means does not contribute any capital but lends his name or credit to the firm. Then next one is sub partner, then partner in profits only, then minor act as a partner. So we will discuss one by one. What is active partner or actual partner? An active partner is one who takes active part in the day-to-day working of the business. So he is the active role. He takes all active role for day-to-day performance of the business. He may act in different capacities such as manager, organizer, advisor or controller relating to the affairs of the business. He may also called as a working partner. So one active partner is treated as working partner. He takes all active role relating to the performance of the business. Either he act as a manager or he act as a controller or anything. He can take active role and others are perform or bound to perform the duties as per the indication made by the active partner. The second one is sleeping or dormant partner. So a sleeping partner is one who contributes capital, share profits, contribute the loss of the business but does not take any active role or working of the concern. A person may have a money to invest but they may not be able to devote time for the business and such person may become a sleeping partner. As the name signifies, a sleeping partner is one who contributes money or money's worth, who takes profit, who suffers loss but do not take any active role for the performance of the business. Only contribution relating to money or money's worth and sharing of a profit or sharing of losses is there, but there is no working role or active role relating to the business. So if any partner having no time relating to contribution or performance of the business, in that case that partner may contribute money or money's worth and that partner is treated as a sleeping partner. Then the next one is nominal partner. A nominal partner is one who lends his name to the firm. He does not contribute any capital nor does he share profits of the business. On the strength of his name, the business may get more credit in the market or may promote its sales. So nominal partner only lends his name to the partner. He is neither a partner but only gives his name to the firm and by his name the firm takes credit or increases his sale. He takes the profit or he provides all types of direction relating to the performance or the growth of the business, but he is not a role or actual partner relating to the business. As he is a nominal partner, his role is to provide all direction relating to the performance or the growth of the business. That's why that partner is called as nominal partner. Then sub partner. A partner may associate anybody else in his share in the firm. He gives a part of his share to the stranger. The relationship is not between sub partner and the firm but between him and the partner. So sub partner generally partner's partner. That means in certain cases a partner may associate with anybody else to share his profit. Even to a stranger the partner can share a part of his sharing profit to that person. And the relationship is not between the sub partner and the firm but between the person or the stranger and the partner. So the sub partner is non-entity for the partnership business. He is not liable for the debts of the firm. As he is a stranger to the firm, he is not a partner. So in that case, he is not liable for any of the debts if the partnership business arises. Then next is partner in profit. A person may become a partner for sharing of a profit only. He contributes capital and also liable to third party like other partners. He is not allowed to take in the management of the business and such partners are associated for their money and goodwill. So partner in profit means the partner who takes only the profit amount or sharing of profit relating to a partner, that partner is known as partner in profit. He contributes capital and also liable to third party, but he is not liable for any amount of a loss if business has suffered. He takes only when there is profit. That's why it is known as partner in profit. Then the next one is minor as a partner. A minor is a person who has not yet attained the age of majority. A minor cannot enter into a contract according to the Indian Contract Act, but a contract by a minor is void ab initio. However, a minor may be admitted to the benefits of partnership business with the consent of all other partners. The minor is not personally liable for liability of the firm, but his share in the partnership profit and profits of the firm will be liable for the debts of the firm. So first we have to know that who is a minor. Minor means any person who has not attained his or her 18 years of age. So as per Indian Contract Act, minor is not liable to enter into any type of a partnership business, or minor is not liable to form any form of a agreement or not a valid contract. So as agreement with minor is declared as void ab initio, so partner or minor is not a partner, but he may act as a partner, or he contribute money, or he takes the profit, or any amount of a loss is there. In that case, the loss is absorbed, or loss that is reconciled the amount of a profit or the property which is contributed during the starting of the business. As minor is not liable or not eligible to take any type of a decision, so in that case, in certain cases, minor can also be liable as a partner or act as a partner for the benefits of a partnership business. Then the next one is kinds of a partnership. There is a particular diagram that here it is mentioned. One is on the basis of a duration, that is partnership at will and a partnership for a fixed period. And second one is on the basis of extent of the business. One is particular partnership, second one is general partnership. So first one is partnership at will. This is mentioned under section 7 of the Partnership Act. It is a partnership when no fixed period has been agreed upon for the duration of a partnership business, and there is no provision made as to determination of a partnership. As it is partnership at will, so there is no fixed period relating to the duration of the business, and also there is no provision relating to the determination of a partnership. The second one is partnership for a fixed period, where a provision is made by a contract for the duration of a partnership. The partnership is called as partnership for a fixed period. So this is mentioned, that is fixed period. That means the partnership business is conducted for a fixed time period, and within that period the business is conducted, and when that period is over, the partnership may continue or may not continue. That depends upon the agreement or the terms and condition or mutual discussion. The next one is particular partnership and general partnership. Particular partnership means a partnership may be organized for the prosecution of a single adventure as well as conduct of a continuous business. So when partners they continue their business in a repeated nature or continuously year after year, in that case, or that is for a single activity of a business the partners continue, that is called as a particular partnership. But in case of a general partnership, where a partnership is constituted with respect to business in general, that means the partners they can continue all type of a business activity. There is no fixed proposal or fixed type of a business activity. That's why it is called as a general partnership. That means partners conduct all type of business as per the terms and the contract made in the partnership agreement. Then next is partnership deed. This is very important during the formation of the partnership business. So partnership, as it is formed by an agreement, this agreement may be in written or in oral. Though law does not expressly require that partnership agreement should be in writing, but it is desirable to have it in writing order to avoid the dispute with regard to terms of the partnership. The document which contains the terms and conditions of partnership as agreed among partners is called as a partnership deed. So we already discussed from the beginning that partnership is the relationship between partners, and the agreement of the terms and the conditions they have to mention during the starting period of their business. So as they continue their business, their agreement must be made during the starting period, and that agreement may be oral or in written. It may be expressed or it may be implied. There is no specific rules that agreement must be in written, but as they are the partners or more than two persons are associated with that, or two persons are associated with that, so in order to avoid any type of a problem or a dispute relating to performance of their business, they must have to be form a written agreement among all, and that must have been made in the form of a document. So the document which contains the terms, conditions, facts, everything relating to the performance of the business or carrying on the business activity, that is known as partnership deed. The partnership deed is duly stamped as per the Indian Stamp Act, and that is duly signed by all the partners. So that is another important part. When a partnership deed is formed, that deed must have been stamped by all the partners as per the Indian Stamp Act, and all the partners must have to give their signature in the form of the document, or which is called as partnership deed. Then the next one is what the partnership deed contains. What are the contents? A partnership deed may contain any matter relating to the regulation of partnership, but all provision in the deed should be within the limits of the Indian Partnership Act 1932. And however, a partnership deed should contain the following clause. First one is the nature of the business. That means what type of a business they are going to form, or the partners are going to form, that must have been mentioned in their partnership business. The second one is the duration of partnership. That means the time period, whether this is general partnership or particular partnership, or this is for fixed period, or that is called as partnership at will. Whatever may be, the duration must have been mentioned in the partnership deed. The next one is the name of the firm. That means the partnership business when carried on, the business name must be mentioned. Where there is no name, there is no partnership firm, or there is no partnership business. Then the capital, which is very important. The persons those enter into the partnership business, they are called as the partner. So they must have to be contribute their money or money's worth relating to the partnership business, and that money or money's worth is known as the capital to the partnership business. Next is share of partners in profit and loss. The profit sharing ratio, that must have been mentioned in the partnership deed, and if losses is there, they must have been mentioned, otherwise that loss will be set off, or that will be shared equally among the partners. Then bank account firm, as firm or partnership firm is a separate identity and existence. So for the performance or for accounts related purpose, there is a bank account of the firm, and that must have been with any nationalized or commercial banks. Then books of accounts, as partnership business is carried on with certain members, so there is a books of accounts where everything relating to the performance or relating to the income, expenditure, whatever activities made relating to the business, that must have been mentioned in the books of accounts of the partnership firm. Then the power of partners, every partner having certain rights and duties. So what are the rights of the partners, or who is the active partner, who is the sleeping partner, everything that is mentioned, and their duties, their powers, that is also mentioned. The retirement and expulsion of the partners. If any partner attains certain age of 60 or more than that, in that case that is called as a retirement. So in which age the partners will be retired, and at the time of retirement what are the benefits, retirement benefits will be made relating to the partner, that is also mentioned in the partnership deed. Then death of partner, if any partner dies during the continuing of the business, then in that case how the business will be conducted after the death of that partner, or who will be the legal heir of the partner, or who will enter into that particular place, who is going to dead or already dead, everything relating to death of partner, that is mentioned. The next one is dissolution of the firm. That means when the partnership firm comes to an end, in that case what will be distributed, or the assets or liabilities, how that will be set up, how that will be carried forward, everything, or what is the mode of dissolution. In every cases that must have been mentioned relating to the partnership deed. And the last one is settlement of a dispute. If any partner having making any problem relating to partnership business or during the conduct of a business activities, that is called as a dispute, and in what way that dispute can be settled, that is also mentioned. Whether there is any penalty or provision or anything else is there, that is must mentioned in the partnership deed, and all the partners must bound to follow if they are having any defaulter or any dispute arises among other partners. In next class we will discuss the rights and the duties of partners, and the mode of dissolution or different ways when partnership firm is get dissolved or comes to an end. Have a good day to all of you.